the Solicitor General in the Philippines, and I am Sarah Baffadell, External Counsel assisting in this matter. Thank you.
Thank you very much to you. Could I please ask the Office of the Prosecutor to introduce themselves?
Good morning, Your Honour. Appearing for the prosecution this morning, trial lawyer Colin Black to my right. Directly behind me, Associate Trial Lawyer Inbal Jalowski. Behind me to my right, Associate Trial Lawyer Robin Croft. And I am Senior Trial Lawyer Anton Steinberg. Thank you.
Thank you very much. Could I ask the legal representative for victims, the OPCV, to please introduce themselves?
Merci, Monsieur le Président.
Thank you, Your Honor. The OPCV is represented by Ludovica Vertruccio and myself, Sarah Palais.
I think VPRS is present. Could they please introduce themselves? No? Yes, sorry.
Good morning, Your Honor. For VPRS, on my left, Alexandra David, and myself, Soraya Brexi.
Thank you very much indeed to all of you. So today the Appeals Chamber will deliver its judgment in the appeal of the Republic of the Philippines against Pretrial Chamber 1's decision of 26th of January 2023, entitled Authorization Pursuant to Article 18.2 of the statute to resume the investigation. I shall refer to it as the impugned decision. This is a non-authoritative summary of the Appeals Chamber written judgment in the appeal. The written judgment, together with a dissenting opinion that is appended to it, will be made available and notified after this hearing. I will now briefly explain the background to this appeal. On the 17th of March 2018, the Philippines announced its withdrawal from the Rome Statute, which became effective from the 17th of March 2019, pursuant to Article 127(1) of the statute. On the 24th of May 2021, the prosecutor requested, pursuant to Article 15(3) of the statute, that the pretrial chamber grant authorization to commence an investigation into the situation in the Philippines. On the 15th of September 2021, the pretrial chamber issued a decision authorizing the commencement of the prosecutor's investigation. On the 18th of November 2021, the prosecutor notified the pretrial chamber that he had received a deferral request from the Philippines pursuant to Article 18.2 of the statute. On the 24th of June 2022, the prosecutor requested the pretrial chamber to authorize the resumption of the investigation into the Philippines situation pursuant to Article 18.2 of the statute. On the 26th of January 2023, the pretrial chamber rendered the impugned decision authorizing the prosecutor to resume the investigation into the Philippines situation pursuant to Article 18.2 of the statute. On the 13th of March 2023, the Philippines filed its appeal brief, raising the following 4 grounds of appeal. First, the Philippines alleges that the pretrial chamber erred in finding that the court could exercise its jurisdiction on the basis that the Philippines was a state party at the time of the alleged crimes, despite its subsequent withdrawal from the statute. Second, the Philippines alleges that the pretrial chamber erred in reversing the prosecutor's burden of proof in the context of Article 18 proceedings. Third, the Philippines alleges that the pretrial chamber committed an error of law in its application of the legal standard applicable to a case, overstating the degree of overlap required in the Article 18 context, which invalidated the entire admissibility assessment. The Philippines also alleges a number of errors in the pretrial chamber's findings on specific domestic proceedings and on the degree of overlap with the court's investigation. Fourth, the Philippines alleges that the pretrial chamber's finding that it was not satisfied that the Philippines is making a real or genuine effort to carry out the investigations and prosecutions is not based on any actual assessment, and that the pretrial chamber failed to consider whether the situation is of sufficient gravity. The Philippines seeks the reversal of the impugned decision. Before I address the merits of the appeal, I would like to state that it is rejected by the appeals chamber by majority, and that the impugned decision is therefore confirmed. I will now address the merits of the appeal and the appeals chamber's findings. Under the first ground of appeal, the Philippines alleges that the pretrial chamber erred in finding that the court could exercise its jurisdiction despite the Philippines' withdrawal from the statute. The Philippines also argues that it is entitled to raise this issue in its appeal, as the impugned decision contains a positive finding of jurisdiction based on the Philippines' status as a state party to the Rome Statute at the time of the alleged crimes. The appeal chamber by majority, I and Judge Orkepanidze dissenting, finds that the Philippines sets out the alleged errors in a manner that renders unclear both the precise nature of its challenge as well as the legal basis pursuant to which the challenge is made. The appeal chamber by majority observes that the impugned decision does not constitute a decision with respect to jurisdiction within the meaning of Article 82(1)(a) of the statute. While the pretrial chamber addressed the issue of jurisdiction in general terms, the impugned decision is not a decision on jurisdiction. Contrary to the Philippines' assertions, the findings of the pretrial chamber, in particular those concerning the court's jurisdiction over the present situation, and the effect of the Philippines' withdrawal on the court's jurisdiction, are not a positive finding of jurisdiction that is inextricably linked to its admissibility rule. Rather, the pretrial chamber simply recalled and reaffirmed its previous findings on jurisdiction made in its decision authorizing the investigation under Article 15 of the statute. Furthermore, the issue of the impact of the Philippines' withdrawal from the statute on the court's jurisdiction was neither properly raised nor adequately ventilated before the pretrial chamber. The appeal chamber, by majority, Judge Orkepanidze and myself dissenting, therefore considers that the appeal chamber cannot entertain the Philippines' appeal at this point. As a result, the appeal chamber, by majority, Judge Orkepanidze and myself dissenting, dismisses the first ground of the appeal, of the Philippines' appeal. As a result of the dissenting opinion of Judge Orkepanidze and myself with respect to the first ground of appeal, the following grounds of appeal are only considered by the majority of the appeals chamber. Under the second ground of appeal, the Philippines alleges that the pretrial chamber erred in reversing the prosecutor's burden of proof in the context of Article 18 proceedings. In support, the Philippines argue that in Article 18 proceedings, the prosecutor, as moving party, bears the burden of proof. It is because, in its view, the state is not the party seeking to change the status quo. Rather, the prosecutor is seeking a preliminary ruling regarding admissibility to end his continued deferral after having received a deferral request from his state. The majority recalls that Article 18(2) of the statute provides that a state may inform the court that it is investigating or has investigating the relevant persons and request a deferral. The majority further recalls that Rule 53 of the rules requires the state seeking a deferral to provide information concerning its investigation. The majority notes that by informing the court that it is investigating or has investigated and requesting deferral, the state concerned is alleging a fact. The majority is of the view that the court's legal text place the burden of proof in Article 18 proceedings on the party which seeks to establish the existence of a fact. It is thus incumbent upon the state to establish the facts supporting the assertion. Recalling Rule 54.1 of the rules, the majority notes that when the prosecutor seizes a pretrial chamber with an application for a ruling under Article 18 statute, the pretrial chamber, in its determination of the prosecutor's application, relies on the information which the state initially provided to the prosecutor. As a result, the burden of providing information relevant to the pretrial chamber's determination under Article 18.2 remains on the state seeking deferral, and the prosecutor's subsequent duty to communicate to the pretrial chamber the information initially provided by the states in support of its deferral request does not affect the allocation of the burden of the proof. For the foregoing reasons, the majority finds that the Philippines has failed to demonstrate that the pretrial chamber erred in placing the onus on the Philippines to show that investigations or prosecutions are taking place or have taken place. Therefore, the majority rejects the second ground of appeal. Under the third ground of appeal, the Philippines alleges that the pretrial chamber erred in applying the same person, same conduct test and the high standard of assessment of the degree of mirroring with the prosecutor's investigations, both tests being, in its view, applicable to cases rather than to situations. Philippines provide a number of examples of domestic proceedings which it submits were erroneously assessed. The majority recalls the jurisprudence of the appeals chamber that any investigation, irrespective of its stage, has certain defining parameters. The majority is of the view that for the purpose of admissibility challenges under Article 18 of the statute, a state is required to demonstrate an advancing process of domestic investigations and prosecutions of the same groups or categories of individuals in relation to the relevant criminality, including the patterns and forms of criminality within a situation. The domestic criminal proceedings must sufficiently mirror the scope of the prosecutor's intended investigation. The appeal chamber observes that a pretrial chamber's assessment in this context is a largely fact-driven inquiry. The majority notes that in the present situation, the general parameters of the situation were defined by the pretrial chamber's Article 15 decision and by the prosecutor's notification to the Philippines under Article 18.1 of the statute, and that those parameters were sufficiently specific to enable the Philippines to provide information in relation to its domestic investigations and prosecutions under Article 18.1 of the statute and demonstrate the degree of mirroring. The pretrial chamber stated that it considered whether the domestic investigations and prosecutions of the Philippines cover the same individuals and substantially the same conduct as the investigations before the court. The majority notes that the pretrial chamber, however, acknowledged that its assessment must be carried out in the context of a specific situation and taking into account the different types of investigations. Furthermore, in its application of the test, the pretrial chamber examined whether the Philippines showed, first, that it is indeed investigating and prosecuting the same groups or categories of individuals in relations to relevant criminality within the scope of the situation, crimes related to the war on drugs campaign. Second, that it has undertaken tangible, concrete, progressive investigative steps in its investigations and proceedings. And third, that its domestic investigations and prosecutions sufficiently mirror the content of the Article 18.1 notification, by which the prosecution notifies the concerned states of the opening of an investigation and its scope. In light of the foregoing, the majority considers that in its assessment of complementarity in the context of Article 18.2 of the statute, the pretrial chamber correctly assessed whether there exists an advancing process of domestic investigations or prosecution of the same groups or categories of individuals in relation to relevant criminality within the situation which sufficiently mirror that of the prosecutor, taking into account the stage of the situation as well as the specific circumstances and parameters of the Philippines situation. Therefore, the majority finds that the pretrial chamber did not err in law. The Philippines alleges a number of errors in the pretrial chamber's findings on specific domestic proceedings and on the degree of overlap with the court's investigation. With respect to the pretrial chamber's assessment and rejections of information submitted to substantiate the Philippines' investigation, the Philippines alleges that the pretrial chamber erroneously imposed a high threshold developed in the Article 19 context. For the reasons set out in detail in the judgment, the majority finds that the Philippines has failed to demonstrate any errors of the pretrial chamber in the impugned. As regards the pretrial chamber's assessment concerning the contours of the investigation, the Philippines alleges that the pretrial chamber imposed a degree of mirroring with the prosecution investigations which cannot exist at the Article 18 stage, whereby the contours of the prosecution's investigations concerning a specific case are undefined and unclear. For the reasons set out in detail in the judgment, the majority find that by failing to show instances in which the pretrial chamber allegedly applied the wrong threshold or standard, the Philippines has failed to demonstrate the alleged legal error. Having rejected the Philippines' arguments regarding the application of the alleged erroneous admissibility test and the examples of alleged erroneously assessed domestic proceedings, the majority rejects the third ground of appeal. Under the fourth ground of appeals, the Philippines alleges that the pretrial chamber's finding that, in its view, the Philippines is not making a real or genuine effort to carry out investigations and prosecutions is not based on any actual assessment. The majority does not agree that the pretrial chamber's finding that no real or genuine effort was made was a finding on the Philippines' willingness and ability to carry out investigations. This finding of the pretrial chamber should be viewed in light of the two-step approach that the pretrial chamber applied, which requires it to assess the willingness and ability of the domestic authorities to genuinely carry out an investigation or prosecution only if it first finds that there were ongoing or that there had been investigations or prosecutions.